Hey, this is Alan Gassman, and we welcome you to this presentation entitled Key Trust Language and Why It's Important. Now, if you signed on early, you know that I talked a little bit before we started to record about Michael Nesmith. He was one of the 4 Monkees, my favorite initial rock group. And there is the Greatest Hits album, which I bought in 1981 for $1. And of the greatest hits of the Monkees, only one of them was written by a monkey, and that was a song that I don't recall, honestly, but it was The Girl I Knew Somewhere. The Girl I Knew Somewhere. So you can later ask Alexa to play that song. It's pretty good, as are all their songs. So this presentation is dedicated to Michael Nesmith of the Monkees. Speaking of key trust language and why it's important, it is important. That's why our attendance today is pretty darn good. Please remember, we do not provide continuing education credit. We're very pleased to be talking today for people who want the information, not the continuing education credit. But we do apologize, it's just difficult to register for it. Now, how do you ask a question? You can email me, bottom left-hand side here, agassman@gassmanpa.com, and I will check my emails towards the end of the presentation. Or you can go to your box there and click on the question part, and then type your question in. And I already have one question from John. It says, so sad about Michael Nesmith. Yes, especially he had just performed in Clearwater, Florida, not too long ago with Mickey Dolenz, and I heard it was a great show. Okay, next week, I'm going to talk about avoiding estate and trust litigation and beneficiary squabbles. And then Saturday the 8th, I'm going to talk about how to make your office or business more effective and enjoyable. I give a 6-hour workshop at law schools sometimes when they invite me, which isn't that often, but it's pretty effective, and I'll boil it down to an hour on January the 8th on Saturday. Less about law and more about the business of law and life. And Brandon are going to be speaking for the Suncoast Estate Planning Council on Thursday. I probably won't be there because I'm having a cataract surgery that morning. If I'm done in the morning, then I'll be there in the afternoon, but probably won't be done. So you're in luck. Ken and Chris do a much better job than I do. And I believe if you don't have to be a member to listen to their talk. And then I'm going to be speaking for the FSU FICPA presentation soon. If you're new to our presentations, then you have my condolences. This is not a very good program. You may want to try something better. But if you want to see, if you like to suffer more and you want to see some of what we've done in the past, you can go to our YouTube channel. And in our YouTube channel, across the top row, you will see all these Saturday talks. And then the next row are charitable talks. And then below that are other types of talks as well. You can also subscribe to our free Thursday report. We just issued our 317th issue of the Thursday report on December 2nd, 2021. You know, it's not as good as certain magazines, but it does have a lot of things in it, and it becomes very productive during the breaks when the law clerks are writing very well for us. Okay, I'm going to skip all the spreadsheets. I'm going to skip talking a whole lot about estate tax today. This comes from a talk that Christopher Denicolo and I gave not too long ago for Leimberg Information Services. So I thank Chris for letting me use the slides. If you are a lawyer, oh, I'm sorry, share screen. Uh-oh, I apologize. All right. So you really haven't missed anything. I'm sorry I wasn't sharing my screen. Going back here real quick. There I am, not so good looking. And then upcoming events, you've got key trust language today, avoiding estate and trust litigation on the 18th, and on January 8th, how to make your office or business more effective and enjoyable. Okay, our YouTube channel looks like that, and our Thursday report looks like that, and usually our presentation is better than this. 54 minutes left. Let's cover something worthwhile. If you're a law firm, how often are you updating your forms, or what is your procedure? Is there someone in your office who's in charge of taking all those ideas for improving your forms and getting them into the computer? And if not, is that something that you want to implement in your firm? We are weekly, Ken and Chris and Brandon and I, every week, are looking at forms, looking at changes that we've made in our forms. And a lot of these come from client ideas. So when you see one of our trusts, they are more lengthy than most trusts, but we try to cover a lot of things that can become important in the scheme of life. So some quick examples here for the revocable trust of an older client or an infirm client. And one of the things we find with clients who are beyond reason, not that we all aren't beyond reason to some extent, but I like to have a provision in the trust that says, if one of my children loans money or advances money to help me, then that child will get paid back. And what I mean there is, a lot of times clients call me and say, I can't get my mom or dad to hire a nurse. They're coming back from the hospital. The doctor says they should have somebody with them. I don't want to put them in a rehab center, and they will not pay for a nurse. Well, the answer is just say, hey, mom and dad, I got you an early Christmas present. I got a nurse. Don't worry about it. It's on me. But there's a provision in the trust that gets that child repaid. So I think that can save some lives, quite honestly. When clients tell me they're going to the hospital, I say, who's going to be there when you get home? Well, my spouse who has dementia will help me. That's not good enough. So this is good on the nudge. Number two, a lot of times a client becomes infirm, they need help, and the most imbalanced child who doesn't have a home of their own moves right in. And not only do they move in, but they move in on the assets. So an agreement between the client and the children of the client, where the children say and agree, even if mom changes her will, we're going to go equally. An agreement among beneficiaries is enforceable probably in all 50 states, at least in the states that I've looked it up. So it can be a good idea if you have a sibling or an in-law or a parent where you think that this might become a problem, consider a family agreement not to change the inheritance. Number three, we are commonly using a safety latch provision in our revocable trusts. I don't enjoy when clients get taken by their housekeeper or their new spouse or one particular child to a lawyer's office, and then the client cuts everybody else out or names their housekeeper as their trustee. So you can put a safety provision clause in your documents which say, once I've reached age 78 or whatever age you want to say, I can't change this document unless I have consent from 2 out of the 3 names or from 2 doctors, and those doctors need to be board certified neurologist or board certified psychiatrist, after a 1-hour review session, to make sure that I really do have good memory and that I really know what I'm doing. And for you lawyers who haven't been practicing very long, believe me, you can easily be fooled. I had a situation about 3 years ago where a client came in with his wife and wanted to make significant changes to the document. And I had another appointment I had to get to, and they had to wait an hour for me. So I sent a new law clerk into the room with them, and I said, you know what? Go in there and get his life history. Ask him where he came from, what his life was like, how he became successful, and go ahead and just, you know, entertain them for an hour and take good notes. So she did that. And then I came in after about an hour and 20 minutes, very apologetic, and they had known that there was a possible interruption. And he proceeded to tell me that his daughter lived about half an hour from him. And his wife said, no, your daughter lives about an hour from here. And he said, oh, okay, I thought it was about half an hour. So, you know, I didn't think much of that. So the law clerk and I walked out of the room to talk about what we were doing. And she said, you know, 4 times in the last hour, he has said that his daughter lives half an hour away. And the wife has corrected him to an hour, which the law clerk said means that he can't remember what happened 15 minutes ago. So my antenna went up, and I would not have realized that if my law clerk had not sat with the client long enough. You'll notice a memory issue at sometimes it's 8 minutes, 12, 15, 25. You know, you're just not going to know that if you rush into the room and amend the trust. So I like to have the safety latch provision. It has been approved by judges. Judges have refused to allow amendments to trusts when the safety latch has not provision has been in place. They used to call this a Ulysses clause. I don't know if they still call it a Ulysses clause or not. I call it a safety latch. Okay, page 18. You know, believe it or not, I've had clients say, yes, I have a diagnosis of dementia, but it's mild, so I'm still legally competent. And that is true. You could still be legally competent with dementia. But do you want to be the sole trustee of your trust and be making your decisions when you have dementia? Probably not. So a simple provision saying if I've got any of these diagnoses, then I have to have a co-trustee. And we'll talk more about what the co-trusteeship would be. Bottom of page 18. How about upon request of any of my children, this trust will not be amendable without a letter from a neurologist or all my children, and I have to be co-trustee with my choice of a trust company if any child requires in writing. These are the types of provisions that can save a small fortune or save whatever assets a client has from being lost, stolen, or wasted. Now, a lot of times clients come to us and say, I don't have a revocable trust. I just have an old will from 1974. They completely forgot that there was a revocable trust that they signed in 2001 and they lost it. But there's assets payable to it. So I do a new revocable trust, which doesn't mention the old one, and they die, and the assets payable to the old trust go how it says. It's a mess. So make sure that your revocable trust has a provision that says this will constitute an amendment and restatement of any prior revocable trust, even if I don't remember it. And then I have more language that's later, but equally important. And it says, if I don't have a will that pours my assets into this revocable trust, then this document, this trust, will be considered to be an amendment to my last will and testament or my last will and testament itself, so that all of my assets pour into my trust so that this trust will actually serve a purpose. I had a client, I sent him a will, I sent him a trust. He emailed me, I signed the will, I signed the trust, they're in my safe deposit box, I'm going skydiving. The chute did not open, and it turned out he only signed the trust, not the will. I had no chance to know. All I got was a day before skydiving. I signed them, witnessed, notarized in my safe deposit box. Oops. So, number one, take an extra shoot. But number two, that safety provision in the revocable trust. Now, here's one for the lawyers. A lot of times, clients appoint trust companies, and then the trust company doesn't want to charge, or it's a real small thing, and the trust company has to charge a minimum fee, and it's just a toothbrush. I mean, there's just not much there. So some clients may want their law firm to be able to serve if and when there would be a provision allowing a family member to appoint a trust company. So you'll see later, a lot of my provisions say, when my child turns 40, she can be co-trustee with her choice of any trust company. But she has to have a trust company as co-trustee because I don't want anything bad to happen. Well, the definition of trust company could include the lawyer. Maybe it should, maybe it shouldn't. Maybe it would say the lawyer could serve only if assets are worth less than $100,000, and the lawyer serves on an hourly basis. But it's just something to think about. Now, when you put a provision like this in a trust, you need to make it very clear to the client that it's there so that they can ask for it to be taken out. And that's why we always underline that language if we place it in a trust. It's underlined because we don't want the client to miss it. And it's also described in the description letter. Trustee discretion language. When a trust says the trustee may provide distributions as needed for health, education, maintenance, and support to my undeserving grandchildren. Then the undeserving grandchild says, hey, I need my health, education, maintenance, and support so I can keep surfing. And it says may give it. So is that discretionary or not? And this can be a question of interpretation. So having a provision that says, when I say the trustee may, that means doesn't have to. So that's what the language on page 22 is about. That's 21, sorry. 22, we're going to talk about powers of appointment. A power of appointment is a power given to somebody to direct how trust assets will pass at some particular time. Now, I was reviewing a spousal limited access trust today, and it has about $50 million in it, and it was formed by a husband, and the trustee is the wife, and it is a 30-year marriage, a very good marriage, and there are 3 children of this marriage, and they would like to redirect how the trust assets would pass. They don't want it to go equally to the children anymore. Well, I was hoping that I would find that the wife had a power to redirect how the trust assets would go. And there's language in the trust, but it doesn't apply until after the husband dies. So I said, hey, Floyd, you're okay if you die first. Just make sure you die first. And then after you die, Mary can go ahead and redirect it. And he says, what if Mary dies first? And I said, then you're out of luck. So many powers of appointment only take effect or can only be exercised at the time of death. So here's another example. What if Floyd gave Mary the power to direct trust assets to the children, and Floyd died, and Mary gets approached by the in-laws, and the in-laws, also known as outlaws, say, hey, you can appoint this. Why don't you appoint us $1 million each today so we can go surfing? Well, if the power of appointment is only exercisable at the time of Mary's death, then she's less likely to get accosted by greedy beneficiaries who want her to exercise it. If it says, I give my wife Mary the power to sign a document anytime while she's living to control where the trust assets will go after the death of the survivor of us would be a more thoughtful power of appointment. And sometimes we use language that says you can't exercise a power of appointment unless you have met with a lawyer and discussed it, and the lawyer wrote a letter indicating that she has told you what the implications of the exercise of the power of appointment are. So these are, as Jonathan Blockmacher calls it, a power of disappointment. If you don't behave, you forgot to send me a Hanukkah card all 8 days, I only got 7 gifts, you're out. I'm exercising my power of disappointment. Now, a lot of times wills, the last will and testament will say, here's what I do with my jewelry and my furniture and my appliances, and then they have to go through probate. Or there's a bill of sale signed or an assignment document signed that those assets go into the revocable trust, but it's the will that talks about where they go, so when the person dies, they don't really go there. So the revocable trust should refer to the will to say if there's anything in the will or anything in what we call a separate writing, where under Florida law and many state laws, if the will says, I can leave a list and change the list and check it twice, and when I die, they'll find out who's naughty and nice, and people will get what's on my handwritten list. Well, your revocable trust should also refer to that list in case the items are put in the trust, so you don't have confusion between the will and the trust. And I'll mention the same thing can apply with respect to digital assets. What are digital assets? That's my Facebook account. That's my LinkedIn account. Those are accounts that people want to get into after I die. And you are going to default to state law unless your will or trust has the right language for that. Now, a lot of times, wealthy people are getting their estate plans, and I say, well, on your death, would you like to have a foundation form to be run by your children so that they do charitable things, and this can qualify for the estate tax charitable deduction? Or if the income from your estate pours into this, this can save some income taxes after your death. Oh yeah, that's a great idea. Is it difficult? Is it expensive? No, it only takes the language shown on page 25. So this can be a very good thing. Or leave 1/3 of my estate to my wealthy charitable son, Floyd. But if Floyd disclaims the device, it will go to the Pinellas County Community Foundation to qualify for the estate tax charitable deduction. And I request that the Pinellas County Foundation will follow Floyd's advice, but I don't require that. And they will. So giving charity a chance, yet by a charitable lead annuity trust that can benefit the charity for 20 years and then the remainder goes to Floyd with no estate tax, are something worth thinking about. Do you love your mother? Or at least can you pretend to? So I ask clients, there's nothing in here for your parents. If you die before your parents, are they A-okay? Well, not really, and I don't know if my sister will do a good job or my brother will do a good job. Okay, well, let's leave them a trust, and then let's decide who's going to handle it, and then whatever's left on the subsequent death of the mother can go into the trusts for the children. Here's another nice idea that clients like. You're wealthy, your kids are going to be wealthy. How are all your nephews and nieces doing? Okay. Well, would you like to put $1 million into a trust for the descendants of your parents? So those nephews and nieces and great nephews and great nieces can get educated? Or this could be used on your own grandchildren and great grandchildren. We can make your daughter the trustee, and it will give an incentive for inheritance. I had some clients put $10 million in 2012 into a trust solely for educational benefits for the next 360 years solely of their descendants. So there's language there that may be helpful. We almost always on the first death leave a trust for the surviving spouse, and then on the surviving spouse's death in equal shares to the children unless the spouse otherwise appoints. Do you want to put an adjustment clause that if I die, my spouse is living, and that trust has $4 million in it, and child one gets $1 million and loses it, of course. So now spouse dies, there's $3 million left. Should it be divided equally, or should it be reapportioned because that first child got a lot of assets? So you would address that in your drafting. Now, a lot of times clients say, oh my gosh, I read this trust, Alan, and like to get money out of this trust, the child has to be educated and self-sufficient. And the trust is like a tree, and they can only get the fruit. And they can't get more than $200,000 a year out as adjusted for inflation until they're 65, unless they've got a darn good reason. And they have to talk to the trustee once a year and disclose their information. And if they've ever been in rehab, they've got to see an addiction counselor every 6 months. Why are you doing all this? And the answer is, maybe it helps. Maybe your child will work harder if it's not so easy. Maybe they won't be hoodwinked by a spouse or an advisor. Maybe they'll take life a little bit more seriously and not have their life journey screwed up. Or maybe I just like to put all this stuff in trust agreements because it's fun. This is language that was handwritten by a client of mine. He happens to be a very good spine surgeon, and he hand wrote this, and it was so good I put it in my forms, and it's scary. The trustee can consider all these things. Now, it doesn't say that the trustee can't give them money, but they can consider whether this beneficiary is engaged in illegal activities, whether they're in jail, whether they have a substance abuse problem, whether they're raising a family responsibly, whether they're a productive member of society. The trustee can point to this and say, here's why I'm not giving you so much money. Get your life together. And then do you have an entrepreneurial clause? Some clients want to have an entrepreneurial clause. They made their money being entrepreneurial. They want to make sure their children will have the ability to have capital. And some clients don't want their children to go anywhere near a business. So you have to ask the question. Another drafting tip: a blank in a document. Understand that there's a darn good chance that that document's going to be signed without the blank being filled in. So after the blank, put open parens. If this is left blank, then whatever it is. Blank to spread my ashes. Open parens, if left blank, then my personal representative, close parens. I want blank percent of my estate to go to the museum. Open parens, 10% if left blank. That will solve a lot of issues and a lot of stress later on. So page 33, I have some sample language for limiting the monthly benefits to a beneficiary. Please remember the Robert Heinlein quote: don't ruin your child's life by making it easy. Heinlein, Heinlein, my favorite science fiction writer. He wrote Stranger in a Strange Land. He wrote Job, J-O-B, 2 really good science fiction books. Okay, if my daughter is married, if my son is married, I want their spouse to agree to never the trust that I'm leaving considered in setting alimony, and to never try to reach into that trust. And if they will not sign that agreement, then then that child of mine will not get more than $3,000 a month. So they need to go ahead and make their own living if that agreement is not going to get signed. And by the way, I want this for my spouse also. You can put it in for a spouse also. Okay, one of the things that really has surprised me in the last 10 to 20 years is that the courts and the legislatures are very flexible when it comes to beneficiaries going, well, I know that grandpa said I could only get 200,000 a year, and I know that grandpa said that I had to spend 10 hours a month on charity, and I know that grandpa said I can't get more than what I reasonably need for health, education, and maintenance, but grandpa didn't really mean that. Times have changed, and the surf is calling me. My true meaning of life is surfing. So I would like to reform the trust. Is that okay with everybody? Well, if everyone agrees, then the judge may say, okay, that's fine. So you need to address what it takes to amend the trust. In Florida, you need the approval of the trustee generally and the beneficiaries, and then you can do whatever you want. So if you want to stop that from happening, you can appoint a beneficiary who has a duty to not consent to any changes. And that's what we've done on page 37 and page 38. Okay, beneficiaries with creditors. I don't think I need to mention how important that is. And I know the lawyers out there know what they need to do. Indexing for inflation. Anytime a client says, yeah, I want $500,000 to go to so-and-so, let me tell you, in 10 years, $500,000 may be worth 200,000. So you want to have an inflation adjustment clause. Just put that in your document in case there are any specific dollar amount dispositions. Okay, trustees, please use lawyers and accountants. We're low on business. We need to do something. And we know from experience, trustees who are individuals, family members, well-meaning, well, I paid the right bills. I did what the broker told me to do on the investments. I gave the children the money they need, but oops, the broker gave you the wrong advice and you didn't file the right tax returns. And because you never gave the right notices to the beneficiaries, they can sue you within any time and within 20 years. So you really need to, when you're going to be a trustee, it's a lot of responsibility. And under state law, you can give an accounting once a year. And if the beneficiary doesn't complain within a certain period of time of receiving the accounting, then everything disclosed in the accounting is bulletproof and can't be complained about. So if you're the beneficiary of a trust, yes, I would like to either have an accounting or copies of all the statements. If you're the trustee of a trust, yeah, that lawyer, what a pain, recommending that I get the beneficiaries to waive accountings, to confirm that they accept the investments, or I need to give them notice. So I remember early in my legal career, one of the lawyers I worked with, before she would do anything for a trust or an estate or a guardianship, even sell a car, she would file a motion, give all the beneficiaries notice, go to a hearing, and get it approved. So at least you can encourage the trustees in your trust document to do the right thing. Page 42. At age 60, you say, I want to live at home the rest of my life, but if circumstances occur where I can't afford to be at home, in a loving relationship and companionship and all the services I need, then I want to go to the concierge floor of a nice retirement home where I have my own small apartment and I have friends and I have activities and I have good food and I have music and live entertainment. It's a 60-year-old talking. What does the average 85-year-old say? I'll stay at home, completely isolated, with no one to talk to, because I don't want to leave here. So it's great to have a provision saying I want to be in my home the rest of my life, but that is not where all the fun will be. You will miss so many good parties in your 80s if you're home alone and you don't have 20 friends. So think about that. There's times when we are better off elsewhere or move other people into the home. But elderly abuse is high too, and you have the risk of elderly abuse in the home. That 85-year-old may drive you crazy. So just maybe it's time to address that in your documents. When the client sees that in the document, they can give it some thought. Okay, here's one, and it was just signed on by a neurologist. When I reach 75, I want an annual examination, and if I don't pass it, I won't be trustee anymore. I don't want to be a goofball trustee for myself or anyone else. So that's the provision that the neurologist signed after he read it. Okay. When can the beneficiary take control of their inheritance? For some beneficiaries, the answer is right away, and for some beneficiaries, not so much. If you're a responsible and educated person who has had some financial success, more likely to say, you know what, I don't want it, don't give it to me as trustee. Have the trust say that I can get what I need for health, education, maintenance, and support. Have the trust say that I can direct it to my descendants, but I don't want it in my own hands because I could lose it. It could be subject to estate tax, or it could be manipulated away from me. So what I'd like to be then, in fact, is I'd rather be co-trustee with a trust company of my choice, because I know the trust company will be financially responsible for handling things if I don't. I have an individual co-trustee, they may be careless with that. So here we have, in this clause, parents die, I'm the beneficiary of a trust, I've earned a degree, and I've been self-supporting for 5 years, or the trustee deems me to be stable, willing, and able to support myself. When I'm 30, I can be co-trustee with the trustees serving so I can see what's going on. But at 35, sayonara, Uncle Joe, sayonara, trust company. I'm going to choose a trust company of my choice. I'm going to be co-trustee with them. Now, for some clients, we will say, you can do this at 35, but the trust company has to be one of the 10 largest trust companies in the United States, or from a list left by the client. So maybe that just gives them 12 to 14 choices. And then when they're 50, they could hire any trust company. They could go and interview 100 of them, find the one that's most flexible and least expensive, and hire them there. But this is a very common clause. Then a lot of clients say, well, I don't want a corporate trustee because I've heard these bad stories. Well, I have also heard these bad stories. I've seen many fewer of them than I've heard. But in our documents, normally we do not name a trust company. I think most lawyers say to the client, well, if you're going to have a corporate trustee, I represent that was a Freudian slip. I recommend ABC Trust Company. They're great people. And by the way, they referred you to me. So I strongly recommend ABC Trust Company, because when ABC Trust Company refers a client to me, they expect to see them appointed in the trust document. So then the client dies or becomes incapacitated, and the children say, how did ABC Trust Company get in there? Well, that was what your father chose. Okay, well, they're more expensive than the other trust companies, and they're not returning my calls. Can I replace them? And the answer is, does the trust document allow you to? And the answer is hopefully yes, because it's very difficult to deal with a trust company that's not doing a good job unless you can fire them. So our documents normally say that upon my death, my spouse will choose a licensed trust company. They must have at least $1 billion under management or be one of the following 3 trust companies. My spouse can choose one, has to serve with one, and then can replace them with another trust company, maybe no more often than every 36 months. First of all, the trustee fees will be reduced by about 25% if you walk into the trust company and say, I don't have to use you, I can choose to use you. And then usually the retail trust companies will reduce their fees as a result of that and say, and by the way, if I choose you, I want your best trust officer. I want to meet her first, I want to interview her, and I want to meet my investment officer that will be helping me. So I think that's the 3rd time I've said enough said. So enough said of being enough said. Do you really want a trustee of a trust who's in the middle of a nasty divorce or getting sued by creditors? Probably not. So this will force them to resign during a divorce. Judge, I don't have any control over this trust. Yes, my mom and dad left it to me, but as soon as that spouse of mine filed that divorce, I had to step down as trustee. That money's not available to me. Sorry. Okay. Now I want to talk about, well, let me see if there's some questions here. I know there are. I will answer them. I'll answer some of them. A lot of questions. Good. You guys are absolutely listening. Okay. What language would be required to allow the inclusion of capital gains in distributable net income? That is a really good, important point, Marshall. Thank you for bringing it up. If I have a trust that my parents left me, and it has 50,000 of dividends and interest and 50,000 of capital gains, it pays me 100,000. I'm in a lower tax bracket than the trust. I'd like to pay all those taxes on my own. The capital gains tax still gets paid by the trust unless the trust has language that says the trustee may deem gains to come out with distributions if the trustee determines appropriate in the trustee's discretion. The word deemed came from a Jonathan Blockmacher lecture. So that is very important. That's an important provision to have in the trust documents. Okay, Sharon said, I can't hear anything. Well, Sharon, you're probably the luckiest person in the whole webinar presentation. If you couldn't see anything either from me, you'd be good. Okay, what is the model number of the HP printer behind you? Can it handle high volume, and is it a quick printer? From Stephen. Okay, this one here is a really old HP 4250N, and it works great, and it's very inexpensive. So it's good to buy a used one because the toner cost is much lower. The other one is an HP, is it 4220? It's color. It's a lot more expensive on the toner, but it's nice to have color. They're both quick. Okay. Your assets being in the title of an obsolete trust. There was a failure to retitle the assets into the new trust. What happens if the truster dies before the cure? Well, do a merger agreement that the old trust agrees that it's merged into the new trust. and do that before the client dies. Okay, the safety provision, if no prior will, I think that would require admission of trust to probate in order to be effective. Yes, Richard, I would put the assets into the trust and do the safety provision. And then if somebody tries to ignore it, you would have to go to court in order to have it respected. Okay, this is from VIM. My assets are close to 50 million, including several real estate properties, brokerage accounts, IRAs. How do I protect these assets for my children and grandchildren, as well as my spouse if I die first? And the answer is leave them into one or more trusts that can benefit your beneficiaries with trusteeships where people and or trust companies you trust are going to be around to make sure it's done correctly, and get your estate tax planning done also so that a lot of this doesn't end up going to the government unless you want it to go to the government. Okay, Stephen, is it common for charitable beneficiaries to bear the estate tax costs while family beneficiaries don't bear taxes? Well, you get a deduction for what goes to charity, but if there will be estate tax paid and the remainder goes to charity, then in effect the charity is paying some of the tax. So I guess it depends on how you look at it, but if you are charitable, you should look at some charitable planning techniques, and I've got a lot of charitable planning videos on the YouTube channel. It's complicated stuff, but you can do a lot of neat stuff. Okay, can you tell us more about private education trust for issue? I'm going to get to that. Karen agrees that Heinlein is one of my favorite authors, especially Job, J-O-B. Yep, it's probably pronounced Job. Okay, how to print the material. Send me an email, we'll help you with that. All right, so those are the questions so far. I'm glad that some people are awake. Now we're going to talk about slats. A slat is a trust formed by one spouse that can benefit the other spouse, and it's creditor proof because the spouse that formed it is not a beneficiary or it's in an asset protection jurisdiction, and it is estate tax proof, and it stands for Spousal Limited Access Trust, SLAT. So here are some provisions that we have in our slats in boxes that are optional. One, like I said, should lawyers and your CPAs be considered to be potential co-trustees? They may do a very good job. We need to ask the client, do you want them to be eligible or not? Number two, conservative standards of conduct. This was written by, this was also written by the spine surgeon years ago, handwritten. So it was heartfelt, and his children do understand it. Now, this is a more recent one. This is a client who's leaving about 150 million for each child in trust, and they need to spend 10 hours a month in charity. He wants them to be directly involved with unfortunate individuals so that they can appreciate what they have. And he has significant other charitable requirements in his trust, but this one has been reviewed by other clients who have also selected it. Now here is where this is the beginning of our language of, hey, I think 200,000 a year is all you need. If you want something more, then get a job or, find a way to get it. And your mother and I have always been happy on 200,000 a year. We have a lot of friends who can't be happy unless they have a lot more than that. So one of my other favorite authors, Joseph Heller, once went to a party in a billionaire's house in New York City. And on display in this guy's apartment was all this collectible stuff. And a friend of Heller said, Heller said, I have something that this guy doesn't have and that this guy will never have. And the friend says, what is it? And Joseph Heller said, I have enough. I have what I need right here in my body and in my food, clothing, and shelter. I'm good. And children need to learn that. Parents need to learn that. So this provision helps with that. We could call this the Joseph Heller clause. He also wrote Catch 22. Okay, so, but if the child is raising a family, should they be economically punished? You know, they go and get a PhD and then they have a family, they raise the family, then they enter the workforce 15, 20 years later when the children are all up and out, and maybe they should receive more in consideration of that sacrifice. I mean, to economically punish one of your children because he or she decided to be a responsible parent. So this is just something else to consider. Now, page 53, limitations on the power of appointment. What if the power of appointment says, yeah, on my child's death, she can direct the assets for her descendants, but I don't want any of her descendants to be able to receive more than they reasonably need for health, education, maintenance, and support. And those words, health, education, maintenance, and support, go back to the English Common Law, 1776. And there's hundreds and thousands of cases which tell you what health, education, maintenance, and support means. It means a reasonable standard of living. Does it mean a boat? Does it mean a big boat? Does it mean an airplane? The more guidance you give, the better off your children and grandchildren will be, unless it's your opinion that you should not rule from the grave and that they should be able to just get it all and spend it. If you want them to be able to just get it all and spend it, you can do that while also protecting them from creditors and estate tax. And how do you do it? You say, my son Floyd will be the trustee. He will get what he needs for health, education, maintenance, and support. And he will also have the power to appoint an independent trustee, someone not related to him, someone not employed by him. And that independent trustee will have the power to give Floyd any and all assets for his welfare. Just welfare? You know what welfare is in the English common law? Welfare means anything. Well, I'd be so much happier if that $1 billion was in my personal account than in the trust account. There's no one taking advantage of me today. So for my welfare, would you please move that billion over? That would work. So what have we done for Floyd? Floyd is creditor proofed. He's estate tax proofed. He can tell people that the trust is limited to health, education, and maintenance, but he can also go to page 53 and see that he can appoint his best friend from high school or his girlfriend to be the trustee, and they can give him all the assets. So, and I'll let you in on a secret. Nevada has a very interesting statute. It says if a trust can be used for the health, education, maintenance, and support of a beneficiary, then the trust can be reformed to allow an independent trustee to give the beneficiary more than what they need for health, education, and maintenance. So you could turn a health, education, maintenance trust into what I'll call a Floyd trust, simply by moving it to Nevada and following the Nevada statute. So now, should my trust say, this trust should not ever be construed in a way that would allow an independent fiduciary to give more than what is needed for health, education, and maintenance? The world just keeps going round and round as we do our very best to protect our clients. Do you want your clients to be able to give to charity? One client says in his trust, my children will receive $10,000 a month, but only if they spend $2,000 of it on charitable ventures that they're involved with. That gives them a net of $8,000, and the children are okay with it. They understand that the parents think that that's a good idea. Now, some clients say unlimited amounts can go to charity, because if I change my mind, I just want all this to go to charity. I'll fire the trustee, hire a new trustee, and tell the new trustee to give it all to charity, and my spouse and children won't get a dime. That's good. But then after my death, I don't want more than 3% a year to go to charity, because I don't want to get my family mixed in with a cult that calls itself a charity and then gets all the assets. Now, what if the whole family's wiped out? Do they want a charitable option as opposed to it going to second and third cousins? Or would I like to have it back? So I set up a trust for my wife, my daughter, and my granddaughter. Can I put in that trust agreement that if they all pass away, I get it back? And the answer is yes, if there's less than a 5% chance of this happening under Code Section 2037. Now, don't go try to do this at home. Be very careful on how it's worded, but I've given you the Treasury regulations under Section 2037. So those of you who are not lawyers or accountants who would like to have a really nice intellectual adventure, you can read these regulations, pages 58 through 62, and then tell me what the heck they said. Another question on the slat is, what if there's a divorce? And if I'm funding the slat with assets that were put together during the marriage and we get divorced, I want control of half of them. So part 1 here says, if John and Mary Jo get divorced, there's 2 trusts. One is the original slat, gets half the assets, but the spouse beneficiary can choose and replace the trustee. The second one no longer benefits the spouse, and it benefits the descendants, and the trustee is chosen by the grantor. And then if you have trust protectors who can amend the trust, it should be the trust protectors in the event of a divorce. I mean, if the trust protectors are my brothers and I get divorced, is that going to be fair to my wife? Or is it even going to be fair to me? My brothers may like my wife better than me. So, or should there be a new set of trust protectors? So trust protectors, I only have a minute left here. The importance of trust protectors cannot be understated. Time and time again, clients call us and say, I need to amend that irrevocable trust I sent, that I signed. Do you see, Floyd, it says the Floyd Smith irrevocable trust? Yeah. What do you think the word irrevocable meant? I didn't really pay attention. I just assumed I could amend it. No, you can't. Unless we go to court after giving notice to all the beneficiaries, or unless you appointed trust protectors who can change the trust within certain realms. Boy, good thing I appointed the trust protectors. So a lot of times we see an old trust and we want to improve it. We could either go to court and reform the whole trust, or we could go to court and just ask the court to appoint trust protectors and then let the trust protectors do it later. So there's lots of food for thought here. The other thing for you lawyers is I like to appoint our law firm to be what we call the scrivener protector. And the scrivener protector has the power to replace pages to fix grammar or obvious errors with the consent of one of the or more of the beneficiaries. So when clients call and say, you misspelled my stepdaughter's name, and this sentence is a little bit ambiguous, but clearly what I wanted was this or that, then we can simply, with the consent of one or more beneficiaries, fix that without having to go to court. And this can be very important because when clients die, if you have an unruly beneficiary, they're just looking for any little thing that they can nitpick. So I can say, oh, well, you you're concerned about what this sentence means, well, I just fixed it. I just fixed it. And if you want to complain about it, you can go to court, but this is clearly what your parents wanted, and it's approved by your siblings. So see you next time. So that is the scrivener protector provision. I favor mediation and arbitration. Reason I favor them is because litigation lawyers don't like them and therefore are much more likely to settle a matter, and arbitration keeps things private. So a lot of litigators say you may get a bad arbitrator. Well, if you get stuck with a judge, you're stuck with that judge. With arbitrators, the American Arbitration Association sends you 10 names. You can blackball 5 or 4. The other side can blackball until you end up with 1. You end up at least with a medium good arbitrator, not a terrible judge, and you're in private, you're not in public. So I do personally prefer arbitration. Again, the real reason is because the litigators don't like it and they tend to settle. You can't manipulate an arbitrator like you can a jury. Also, a lot of lawyers say, well, I don't like arbitration because if the arbitrator makes a mistake, you can't appeal it. That's not true. The American Arbitration Association has an appellate process. So that is my hour. I so much enjoy this hour with you. I hope that, as Monty Python said, if I enjoyed this half as much as you did, then you enjoyed it twice as much as I did. I'll be back next week, whether you want me to or not. Please do listen to the Monkees in memory of Michael Nesmith. And next week we'll talk about Tom Waits, and my favorite Tom Waits album is the album that has Step Right Up in it. That is the album called, as you know, Small Change. And who's on the album cover? Elvira. Elvira is on the album cover of the Small Change album by Tom Waits. I recommend that you listen to it immediately and before you see any more of my silly webinars. So thanks again. I'll be answering emails and having a great time this afternoon at the St. Pete Pier with my granddaughter Ava and my daughter Nicole and Marcia. If you're there, I'll be glad to buy you a beer. Bye.